All persons having business before the Honorable Associate Judges, now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save this United States and this honorable court. This honorable court is now in session. Please come to order.
Council, good afternoon. We have one case on the calendar this afternoon. David Young versus District of Columbia Department of Employment Services. Council, Mr. Boscolo.
Your Honor, good to see you. Benjamin Boscolo on behalf of Mr. Young. This case presents a very simple issue, and that is whether or not the workers' compensation law can be interpreted in such a way that an injured worker has no remedy when there is a dispute about a medical service which is necessary. And in effect, what the agency has concluded here, first at the hearings level and then at the Compensation Review Board, is that there is basically not a justiciable controversy because the place in which Mr. Young's medical appliance needs to be housed and used is neither part of the character of that medical care or the sufficiency of that medical care, and therefore they would not address the issue, the dispute between the parties as to the sufficiency of the two alternate proposals for the place in which the medical care was to be provided. And as I pointed out in the beginning of my brief, the statute is crystal clear. I don't frequently say that when I'm in front of you, but it's crystal clear in 1520A when it says the agency shall have full power and authority to hear and determine all questions in respect of any claim. I don't know how the act can be interpreted by an administrative law judge and the Compensation Review Board to say that they do not have authority over this dispute because home modifications are not specifically listed in the statute as part of medical care. I'm surprised this is the first case in the District of Columbia that addresses home modifications. It's actually not an unusual issue in workers' compensation cases. There are cases in both Virginia and Maryland that addressing home modifications and disputes about home modifications and disputes about modifications of automobiles and things necessitated by catastrophic injuries. Clearly, this is a catastrophic injury. And Mr. Young, now for going on 15 years, has been wheelchair bound. And a few years ago, there was a dispute about the need of this Errigo Pro, which is a state-of-the-art piece of rehabilitation equipment that will extend his life as long as he gets to use it. Well, that Errigo Pro has been sitting in a box. Basically, it's not sitting in a box because it's too big to sit in a box, but it's been unused since it was approved by the agency for a period of about 5 years because the home in which Mr. Young lives would not accommodate the rehabilitative equipment. The carrier hired a company to propose modifications to the home to allow the use of this medical aid. And I don't want to get too deeply into the facts because I don't think the agency reached them, and that's not what I'm asking the court to decide today. Mm-hmm. There's a dispute between Mr. Young and the employer and insurer about the sufficiency of the respective plans. That's not the issue that I present to the court today because the agency has not yet reached that.
One question, if I may, as a procedural matter.
Your Honor.
Is this the kind of question that needs to go through some sort of pre-administrative hearing and utilization review process?
I don't believe so. I mean, I think, first of all, utilization review only applies if there's some reason to believe that there is a problem with the nature and sufficiency of the care that's being applied. So I don't think this is a UR case, because nobody disagrees that the home needs to be modified so this piece of equipment can be used. It really goes to what modifications need to be made. And basically the agency said, since, and I'm going to quote from the CRB decision at page 4, and I just don't know what to say about this, because it says modifications of a home do not concern sufficiency or character of medical aid. The CRB said that at page 4. They referred to where the administrative law judge said that, and maybe I didn't understand the word character. And so I did what my millennial kids would do, and I went to dictionary.com and I looked up the word character, and the character is the aggregate of features and traits that form the individual nature of something. All right, and so what the agency is saying is that the place at which this piece of equipment that's necessary to treat this catastrophically injured man is not part of the aggregate of the features of that thing. I don't know.
Consul, I have a question.
Yes,
It
Judge.
sounded to me from your opening that you thought that we could decide this case by looking at section 32-1520A, that was the end of it. And I
Yeah.
take it that you think well, let me ask you, do you think we need to send it back to the agency, or you think we just make that decision and tell them just hear this case?
I think the issue that you raise is an issue of law, Your Honor. And I think all that Mr. Young is asking you to do is say, decide the disputed issue. If Mr. Young loses the issue, Mr. Young loses the issue. But right now he's been told he has a right without a remedy. And if the court won't address the respective points of view on a right, it's not a right at all. And so all I'm asking the court to do is say that under 1520A, the agency has authority to make findings of fact on the character and sufficiency of home modifications. And you can limit it as much as you want. Home modifications.
No, but the question is, you said they didn't get to any of the merits of the case, and I'm wondering whether what you just read from page 4 doesn't starting to get to that. Because if we just say you have jurisdiction on hear the case, won't they come back and say, well, actually, who does the construction doesn't go to the character and sufficiency of the medical service? I mean, isn't this case going to come right back up?
I hope not.
I mean, isn't the handwriting on the wall here?
I don't think so. I think that's also a question of law, because the character and sufficiency language comes out of section 1508
Right.
of the Act. So these are both questions of law. And what I'm really asking the court to say is, you have authority to hear all questions related to this claim, including issues about the character and sufficiency of home modifications. I'm not asking you to say Mr. Young wins, Mr. Young loses. I'm asking you to say he has a remedy where he can go to court and say, this is what I want, and here are the reasons what they've proposed is not right. Please decide. This is just a fundamental nature of justice. And when you have no place to go, now this piece of equipment.
Counselor, I just want to make sure I understand. I mean, the agency thought that it didn't have jurisdiction to decide the contractor dispute. And you're saying we should not go back, because their analysis as to why they don't have jurisdiction is skimpy. So you're not asking us to remand to ask them to explain their rationale. You're saying, please decide that they do have jurisdiction to decide the contractor dispute. But I see you nodding your head. I just want to make clear, you want us to rely on 32-1507 or 32-1520? I had thought from your brief that you wanted to rely on 1507.
Well, I want you to rely on both. I mean, the first 1520 is the overarching principle that if there's a dispute in an issue in a workers' compensation claim, the agency has the authority to dispose of it. 1507 is what talks about character and sufficiency. And I agree that
And
there,
B6 in particular, B6D, I believe, is the one that says that disputes between a medical care provider, employee, or employer on the issue of necessity, character, or sufficiency, right, shall be resolved. So that seems to be pretty clear, plain language that we could hang our hat on. Is that what I just want to make sure that I understand what the request is.
that is the request, Your Honor. And I apologize if I wasn't clear, but the agency does go through that analysis at page 4, and they say that they specifically say that modification of a home does not concern sufficiency or character of medical aid. And so, gee, I don't know what else to say other than the statute says any issue, I guess, again, maybe Judge Ruiz is right. Maybe I'm begging the question. If you send it back and say you have jurisdiction to address character and sufficiency, then they say, well, the modification of the home isn't really character and sufficiency, so we don't. And then Mr. Young waits another 5 years without getting the, I don't want to lose the forest for the trees. I mean, we're talking about a man who's motivated to extend his life, whose wife is with him to use this piece of equipment every day, and it's sitting there being wasted.
I'm sorry, I just want to make sure, because I'm still confused, right? If we're relying on 1507 subsection 6, right? And looking and saying that does define jurisdiction, then wouldn't we be deciding that a dispute between contractors about modification of the home it falls within the character and thus jurisdiction lies, right?
Yeah.
I'm not seeing the divide that you were earlier conceding, and I'm wondering, are you reconceding it, or are you saying there is no such divide? Do you see where I'm confused?
I do, because the word shall means something to me, right? And so the statutory section that you read said that they shall decide issues of character and sufficiency. And they don't have jurisdiction to decide this because it doesn't have to do with character and sufficiency. So I think, and I hope I'm saying the same thing you are, and I'm not talking in circles. I think if you say, yes, you have jurisdiction, the question is answered, because then the statute says you do have jurisdiction over this and you shall decide the issue. I think they all flow naturally from there. I'm just concerned that Judge Ruiz is looking in the crystal ball and saying, doesn't this beg the question of the second finding once you say jurisdiction, that we're right back here on this same finding? So that is my argument, but I am trying to prevent another, much as I love being here, another multiple year trip.
Right.
At-
As
at
I
the end of
read,
my time.
to the extent that there is analysis, and I think it's more in the ALJs, frankly, order than in the CRBs. I think the ALJ said, I have jurisdiction, the agency has jurisdiction to the extent that the dispute, the claim concerns the, whatever it's called, the necessity, character, or sufficiency. And because I don't believe that, it's kind of a, because I don't believe that the choice of contractor, given that everything is identical, which I question also, then I don't have jurisdiction. And that's what I'm saying, that I think that if we just say you have jurisdiction, unless they completely rethink their approach to this, you kind of know what the answer is going to be, which is, does the choice, or could the choice of contractor affect the necessity, character, or sufficiency of medical care, not in terms of jurisdiction, but in terms of whether you're entitled to one contractor over another. And then a subsidiary question, which is more evidentiary, and I think now we would look at as a, well, I'm not sure a decision has been made on that, which is, in this case, would the evidence support that the choice of the contractor in fact goes to the necessity, character, or sufficiency of the medical care? I
That's
mean,
why,
that's kind of, I see this as those kind of 3 tiers of analysis.
that's why it's nice to be a judge and not a lawyer, because you get to go back and look at the compensation order, and I'm only appealing from the CRB's decision. But, you know, I'm concerned. I don't want a Pyrrhic victory for Mr. Young, because if we go back and we spend more time, this man will pass away before he gets the benefit of the equipment, and that's anathema to me. I don't want that to happen, and so I'm concerned. And the reason my argument, Judge Westerly, is a little circular is what I'd really like the court to say is that home modifications and who does them, that's part of character and sufficiency. I know that's probably a factual finding. But I think that this agency could say the place at which the medical equipment is to be used is part of its character, and issues resolving the place at which to be resolved shall be decided under 1507 B6 and 1520A. I know I'm asking for a lot, but I'm afraid that Judge Ruiz is prescient, and we're gonna find ourselves in this quagmire. And so I don't want to say more than that, because I think that's the only issue. The third level, I agree, there's an evidentiary issue, hasn't been reached. It's not before the court, and I'm not gonna burrow down into the facts that have nothing to do with this appeal.
Let us,
Questions, I'm done.
let us give you a few minutes, 3 minutes in rebuttal, and we'll hear from Mr. Snyder.
Thank you.
Mr. Snyder, go ahead.
Sorry about that, Your Honor. Let me address something which I believe is part of the record that leads us to, or at least I believe it helps me understand the ruling from the ALJ and the CRB, and specifically the idea that the plan for the modification for the home is identical to that of the plaintiff or the claimant. So as counsel has indicated, the issue really is, is there authority or jurisdiction to dictate to, in this case, the employer insurer, who to select as a contractor? And actually, in this case, it's a subcontract. But if we're going to talk about a real happening, something that's going to help Mr. Young, we have taken, and the record reflects this, we have taken Mr. Young's proposal. We put aside the proposal that our contractor drew up. We said, take his, make this what he wants done at his place. And in order for them to start that work and to complete it, they need Mr. Young to consent to it. Mr. Young will not consent to it because he does not want to use the subcontractor selected by our contractor.
Mr. Snyder,
Yes, ma'am.
I hate to interrupt you, but are we correct? Am I correct in reading the CRB's decision as basically saying that the ALJ was correct in determining that she did not have, and neither does the CRB, have jurisdiction to decide this claim?
Yes,
Is this a
because
jurisdictional question?
there is no dispute. And that's what, there's no dispute for her to decide. The claimant has asked for home modifications.
Well, that's
The
certainly not
employers
the
agreed to
reason they gave. That's certainly not the reason they gave to say this is moot. They didn't say this is moot. They say we
No.
have no authority to decide.
Well, as I read the decision, if the ALJ had authority to order the employer to provide home modification of a certain character or necessity. And because they had agreed to do it, she did not see that there was a dispute for her to resolve. The only dispute, as she understood it, for this thing to be accomplished was the identity of the person to perform the work. And again, when you go back, one of the findings that she relied upon and the CRB relied upon was the fact that the request for modification and the offer of modification were identical. So that, and I believe that's what the CRB is recognizing, what the ALJ is recognizing, that if you want a home modification and it's been, and you've laid it out, you've got an architectural diagram that has the exact modification requested, well then there's not a dispute to be resolved. It's been agreed upon.
Mr.
And-
Snyder, let me ask
Yes,
you
sir.
about that. I understand what you're saying, but suppose, I mean, in this case, there is a dispute over the qualifications of the two competing candidates for providing that medical service. Why isn't that a dispute? And why isn't it a dispute within the purview of the act? Just take an ordinary case in which the insurance company comes in and says, well, we agree that this man needs a certain level of care. We think a first-year resident can do it, even though it's extremely complicated cardiac surgery or whatever. And so we're proposing he get that service. We all agree this is what he needs, and we have a lot of confidence in this, graduate from medical school will be able to do it. And suppose the patient, the claimant says, no, wait a minute, that's just not satisfactory. We have a dispute about that. I do need this care, and I need it provided by someone who's capable of providing it. And I don't believe this person is capable of providing it. Why isn't that a dispute within the purview of the Workers' Compensation Act?
Because in this particular instance, we're talking about home modification and the
What
method of
difference does
home.
that make? That's what
Or
I'd
in the
like to
man,
explain.
well, because it's not healthcare. And if it's not, if what Mr. Boscolo was arguing is, let's just extend the jurisdiction beyond where it's been statutorily created to a point that it could involve the management of construction sites
Counselor,
at this level.
can I just get an answer on Judge Glickman's hypothetical? Do you agree that there is jurisdiction to resolve that dispute?
The dispute resolving who is the appropriate individual to provide health care? Yeah, I do agree with that, 100%.
Okay. And where in the statute, if we're looking at 32-1507, where do you see the limitation to healthcare?
Okay, if I said that it was limited, I did not mean to say that. What I meant to
I
say,
thought that was your distinction. You said, well, that's healthcare and this is home renovation. So what's the statutory language that you're relying on in 1507 for
The
that
statute-
distinction?
the statutory language concerning character sufficiency of the care. Unless I'm mistaken, in what I thought was a very plain reading of the statute, there's no reference to construction management. There's no reference to construction methods.
Well, it
And I
talks
think
about
you'd-
care, I'm sorry, it talks about care or service furnished, right?
Correct.
And
uh,
if the manner in which a service is furnished depends on its location, why wouldn't that encompass home renovation, as Mr. Boscolo says, it often is the case in workers' compensation cases?
Because I believe that is medical care, not
Well-
construction care. And I think that's the difference in the analogy, that if we're talking about a first-year resident versus a very experienced surgeon to perform a procedure, clearly that is within the jurisdiction and purview. But when we're
May I ask
talking
you a
about,
question,
Yes,
Mr.
sir.
Snyder, about that? Why is it that the insurance company in this case is paying for the home construction if it is not medical care?
because we agree that the tool or the treatment medium, this piece of equipment, we agree that it is a necessary component for the medical care of the claimant.
Sure,
And
but
so
under
we-
that logic, you would just pay for the machine. You wouldn't pay for the home renovations, right?
Well,
You would say, look, yeah, of course, you need this machine, we'll give you the machine, but where you put it in your house, how you get it installed, whether or not it fully functions in that space is, properly accessible, is ventilated, is adequately, supported by sufficient, power. That's your problem. We don't have to cover that because that's not medical care. That would seem to be the logical extension of your argument, but that's not the position that you've taken.
well, I think the position that I've taken is that yes, as Mr. Boscolo has said, a remedy without any meaning is not a remedy, and we recognize the fact that home modification is necessary. It is part of the healthcare, but there is a line which at some point the management of providing of these services in reality has to be left to the people that are actually providing that service, particularly if there's actually a problem that arises with it. And in this particular case, we have, as I said, an architectural
But
drawing.
doesn't that just get into the merits? I mean, maybe, right? Maybe somebody will look at this if the dispute goes back to the agency and they'll say, look, there's really no difference between it's the same plans and these are two capable contractors and this just doesn't matter. Maybe that will be the ultimate result of
Well, the
the
problem
disposition
with
of this dispute, but I don't understand why that obviates consideration of the dispute at all.
Well, the dispute, as I read the appeals from the findings, was that the requested relief was not being provided when the requested relief was agreed to and stipulated it would be provided. The only disagreement is the management of that. Who is the identity to provide the relief requested? And we are outside healthcare at this point. Again, we are now into construction management, and the issues that we've brought up in regards to this, the reason we're not just saying, fine, go use whoever you want to, we're now faced in a position that conceivably we could be ordered to use the contractor of the claimant's choice who does not have workers' compensation insurance. And now
Again, that sounds like a merits argument to me.
Yeah.
Not
I'm
a statutory interpretation jurisdictional argument.
Well, I'm saying this is part of the reason why opening that door is of no benefit to anybody who's seeking relief under these circumstances, because
ask
now
you
we're
then-
going to. Yes,
I'm
Your Honor.
sorry. Well, I apologize for interrupting, but what I guess I'm wondering is this. There is a dispute here over construction management, as you call it. Now, if the AHD, if the Department of Employment Services does not have jurisdiction to resolve that dispute, do you think any other entity, a court, any other entity would have jurisdiction to resolve this dispute?
I think that if we
And
deliver
if so, what law would they apply in resolving it?
Oh. Well, if we're providing this home modification, it's pursuant to the order of AHD, where we've agreed to do that, and that's where the order originates, and where the order says it's been agreed upon that there's no dispute that we do that. If it turns out, as Your Honor has said, that you're not getting the benefit of this because it hasn't been delivered the way it should be, I think the jurisdiction remains with DC to come back to say this equipment is not being able to be used by the claimant. He cannot access it, or he cannot derive the benefit of it because, in essence, he's been barred from it. I think
So the
more,
AHD, so if I understand you correctly, the AHD would have jurisdiction to resolve a dispute if, after the work is done, Mr. Young claims that it was done poorly and he's not getting the benefit of it.
if
But
that
if
is,
he wants to have that issue resolved at the outset by saying, in effect, they are going to do it poorly, and that's why I don't want them. He can't get that. They don't have jurisdiction to handle that question.
well, I think in order to have that for the AHD to have the jurisdiction to resolve that issue, would have to be presented as the medical benefit that has been ordered and agreed upon is not being provided.
Well, what he's
And
saying
then
is,
you would
that's
have a
what he's
hearing on
saying.
that issue.
I mean, it sounds like what he is saying, one way to look at what he's saying, perhaps you would say, is that his claim is that if you let the insurance company go ahead with their contractor to do this construction, I will not get the medical benefit to which I'm entitled, because they'll do a bad job and they'll mess it up, and they'll be, or whatever his objections to their work are. That sounds like it falls within a dispute over the sufficiency of the medical care and service being provided.
Well, I beg to
Is it
differ
not?
in that.
You don't think
I
so?
think it's not even a small step. It's a large step. Where we've agreed on the medical service that needs to be provided. We've bought the equipment. We've taken the claimant's request for home modification, and we said, this is what we will do. And there's no dispute to that. There's
but there's a question as to how it will be executed. There are other things other than home remodeling, for example, that are provided as medical services or under the statute. For example, sometimes there's vocational rehabilitation services. You know, this talks about crutches, false teeth, prosthetic appliances, all kinds of things. And you're saying that if a claimant, where it's agreed that he or she is entitled to any of these things, were to say, you know, you're planning to use that false teeth supplier, and let me tell you, they gave me some false teeth 3 years ago that you know, caused me all kinds of problems. I just don't want you to go with them. I want you to go with this reputable, proven false teeth provider.
Well, I think we already have a resolution to that problem. If the healthcare provider says these are the teeth that you should use, then that's what we do. We provide those teeth. And in this case, we have the manufacturer's representation of what needs to be done to the home. We have an architect hired by the claimant saying, this is what needs to be done to the home. We have a contractor who has said, here is the drawing we will do to your home, but the identity of the subcontractor who will do the work is suddenly becoming an issue. And I think all of a sudden, again, as I've said, we're getting into an issue. Are we supposed to be doing construction management at this point, or are we supposed to be providing a health service? And as the record, you can easily conclude from the record that had they had picked a contractor that we could hire, who had the coverage, we could have done this. Instead, they want to use a contractor without that coverage. We've put in the record the fact that we require proper workers' compensation coverage for people on the work site. And this issue should have been resolved years ago.
That's the only reason why the insurer prefers, I can't remember what the name of the contractor is. It's not a price issue or anything else.
No,
It's only the workers.
The depositions, part of the record is the deposition of the David Corey representative who said, we contacted the claimant's contractor and said, pursuant to our operating guidelines, will you make sure your workers are covered by workers' compensation insurance? And they say, we have no employees. We don't have any control over what our subcontractors, who we are bringing onto the job site, have as way as coverage. A very simple thing to require certificates of insurance. That's the only thing keeping this thing from happening.
Okay. Well, let us hear from, I take it you've reached the conclusion of your argument.
I have.
Let us hear from Mr. Boscolo. We'll give him 3 minutes in rebuttal.
Thank you. If there was no dispute in this case, Mr. Young would be exercising on his Ergo Pro every day right now. All of the things that the employer and insurer argue here, had that been the basis of a denial of Mr. Young's request, I'd be in a pretty tough spot and I'd have a tough row to hoe when I'm asking you to find against that conclusion on a substantial evidence basis. That's not what they did. There is a dispute. The first thing the employer said is, there's no dispute. Well, why are we here? We're here because there's a dispute about the character and sufficiency of the modification. The plans are not the same. They don't cost the same. And the qualifications of the people executing the plans are not the same. All that needs to happen is that dispute is resolved. And under the statute, the agency should have done that and could have done what the employer and insurer argue here and may still do that. But that's not what they said. They said, we don't have jurisdiction. We're not going to resolve this dispute. And a right without a remedy is not a right at all.
Okay. Counsel, thank you both. The case is now submitted.
This court is now adjourned